So, hi, do you know what the First Amendment?
The freedom of speech.
There's also freedom of assembly, and I'm here to tell you how it was born. DeJong versus Oregon was a Communist Party meeting, and DeJong went to, and the Communist Party during then was known to be violent. So Oregon sued DeJong saying, you are being violent and causing a disruption in the peace. DeJong sued back saying that it's my First Amendment right to be there, and the Supreme Court found that any meeting, no matter how violent the ideas were, if the meeting itself is peaceful and advocating for peace, nothing is illegal. And then also the Brandenburg versus Ohio case, which is the KKK, stated that no matter how violent the speech is, it is okay if there's peaceful if it's peacefully done. And then also the NAACP versus Alabama said that you can't force someone to publish their membership lists unless with justification.
All right.
Now, do you feel like you learned more about the First Amendment?
I do know more about the First Amendment.
All right.
I know a little bit, not enough to be dangerous.
About the history?
I don't. Tell me about it.
So, McDonald versus Chicago was banning any guns after 1982 in a loophole, and then they went all the way to the Supreme Court. But McDonald won. The Supreme Court said that they selectively incorporated the right to bear arms. And then versus Casino versus Massachusetts, they said all guns President has are considered like their guns. They're like tasers, and now you can have them. You have the right to bear them. And then Rowling versus New York, you do not need to have a special news to carry a gun. So all of this has created the Second Amendment today. How much have you learned?
I've learned a lot today.
All right.
It brings up a lot of...
I'm Mr. Evolve. How much do you know about the Eighth Amendment?
The what amendment?
The Eighth Amendment.
I don't know anything about the Eighth Amendment.
I'm here to tell you about it.
That's great!
So here's the first precedent that was set by the Eighth Amendment. England versus Clary was that New York officers living in dormitories had a strike, and their boss kicked them out saying, I'm having the National Guard come in here and do all stuff. And then the Supreme Court found that Clary was wrong, but they can't kick them out because even though they don't own the house, they still technically live in the house, so you are allowed to live in your house even if you don't own your house, but the government can't kick you out. And the second case was Katz versus U.S. saying how the Third Amendment was used as how privacy is important in the Constitution, plus the Fourth Amendment to show that tapping to the phones needs a warrant. It was using combination for that. And then versus Griswold versus Connecticut, plus the unstated right said that you can't ban contraceptives in someone's house. That's infringing on the Third Amendment. The U.S. government cannot be inside your house and enforce laws in there. Do you think you've learned a lot about the Third Amendment?
Yeah,
All
thanks.
Ms. Mills, what do you know about the Fourth Amendment?
I don't know anything about the Fourth Amendment.
Do you know about the history about it?
I would love to.
So in Mapp versus Ohio, there was Mapp's home was raided because they thought a bomber was in it, and in that they found that he had some other stuff in there, some legal pornographic stuff in there, and they had arrested her, and that it was basically evidence. But the federal court said that Supreme Court said that any illegal evidence is admissible, and that made the exclusionary rule. And then in Terry versus Ohio, police have to have a reasonable suspicion to stop someone, and they can't just stop them because they want to. And in this, they found a reasonable suspicion that this guy did stop someone, and they found a gun, so that created the reasonable suspicion precedent. And then in United States versus Jones, they said that GPS needs a warrant. So now if you have a GPS tracker, they need a warrant for that. So do you think you've learned a lot today?
I have. Thank you very much.
All right. That's it. Hi, Officer Gilbertson. Would you say you know a lot about the Fifth Amendment?
Yes,
Do you want to know the history about the Fifth Amendment?
sure.
All right, so the most important one in the Fifth Amendment is Miranda versus Arizona, which established Miranda rights in the first place, where External Miranda is arrested and then was interrogated for 6 hours without his Fifth or Sixth Amendment being prescribed to him. And because of that, the case was thrown out, and the Supreme Court has now created the Miranda rights, where you have to tell them their rights of staying quiet and the right to a lawyer. But then also there was the Edison versus California, which was the fruit of the poisonous tree. Edison said was being informed of his Miranda rights, and the person said, I already know Miranda rights. Edison said, I don't care about them, and then showed some physical evidence voluntarily, and then the prosecutor said it's inadmissible because he didn't read his full Miranda rights. This was a warning to police officers to make sure to read the full Miranda rights, even if they say I don't want Miranda rights. But it also set the standard that any physical evidence through a voluntary statement is still admissible, even if it wasn't with a full Miranda warning. And then through Alice versus Illinois, that any psychiatrist examination of a person is perfectly fine because it is not the psychiatrist using the own words of the person that we hearsay, it is them giving an assessment, and any attempt to say that's admissible is incorrect. Would you say you learned a lot today?
Yeah.
Hi, Mr. Paulo.
Oh, hey.
What do you know about the Sixth Amendment?
No, it has something to do with the courts.
Do you know about the history about it?
I think it has to do with the American Revolution. That's all I know.
All right, so I'll name some cases. So Swain versus Alabama set the precedent that at the time they did not find that it was racially biased. Swain was a black man who had an all-white jury, and the prosecutor used premature challenges to remove any other chance of black jurors. And the Supreme Court found that they needed consistent and systemic evidence to prove that it was racial bias, and Swain was executed. But then in Batson versus Kentucky, they said at that time there was consistent and systemic evidence, and that the prosecutor tried to use unfair challenges was not allowed to anymore. And then that precedent was further extended to gender in Jebb versus Alabama, where the father said that you can't have an all-female jury, it's unfair, and then the Supreme Court said yes, unless very specific circumstances. So do you think you've learned a lot today?
I have learned a lot today. Thank you.
All right. So Pete, how you doing?
I'm doing good. What do you want?
I want to interview and read these cases with someone for my documentary, and you seem like the perfect person for it.
I don't get paid enough for this, but fine.
All right, the first case is Beacon Theaters versus Westover. Here's some images from that.
I don't know anything about it.
I would assume so, but okay. But well, it's about Fox Theaters and Beacon Theaters arguing about antitrust laws and how. But that doesn't matter. What does matter is what happened between Beacon Theaters and the court. Beacon Theaters wanted a jury, and the court said no, thank you.
As I said, I don't know it, but I guess I can argue for Beacon.
Now I will. All right. So Beacons deserve the right to a jury, because in the Seventh Amendment, the right to jury is guaranteed, and any attempt to limit that is unconstitutional, no matter what.
Yes, the Seventh Amendment does state that, and we recognize that, but this is more of an equitable issue. It'd be better for Beacons to get a judge anyway. It's common sense that legal issues are for juries. Lock-in representative.
Let's see what the Supreme Court says.
Why are you harassing him so much?
In a decision from 5-3, we have decided that Mr. Lucky's argument is whack. That though the right to a jury is universal, and any limitation to it is unconstitutional. It does not matter if it's more of an equitable issue. Beacons has a right to a jury no matter what. We are setting this standard that the right to a jury is universal, and any limitation is unconstitutional, unless in the most severe circumstances. Yay!
Yeah, okay, let's do the next one now.
All right, this time it's Derek Keene versus Wood.
I know this one too.
All right, let me just say the story again for the viewers. McCulloch and Dairy Queen were arguing over the trademark, and McCulloch sued Dairy Queen for using his trademark and stuff like that, but also wanted money that is owed because it used Dairy Queen as trademark without. So then Dairy Queen, again, like Beacons, wanted a trial by jury. Wood and the appeals court said nope, and it's again an equitable issue, and you only need a judge.
I call dibs on DQ.
Dang it! Fine.
DQ reserves the right to a jury as it is again protected by the 7th Amendment, and any attempt to block that right is illegal and against the Constitution. You may try to argue that it's an equitable issue, but that is irrelevant. If they want a trial by jury, it must be provided.
But it's common sense that a jury deals with an equitable issue, and that we're doing this for DQ. You know, it's more efficient and better for them. They don't need a jury; it's not necessary for this case.
The Supreme Court, in a decision of 7-0, rules in favor of DQ that the right to a jury is specifically stated in the 7th Amendment and protected. That if someone requests a trial by jury, they must be given it, barring the most extreme of circumstances.
I lost.
That was fun. Now get out in the 6 to 7 seconds, or else.
Okay, bye.
Get out of here, Hussein.
I'm good. I'm leaving.
I'm Mr. Stan. What do you know about the 8th Amendment?
I know that it exists.
Do you know about the history?
I do not know about the history of
I'll say some cases that set the history for the 8th Amendment. So there's the Fulman versus Georgia case that said that death penalty is now off limits. It said that the death penalty is too sporadic and too random and too biased to even let allow happen. That banned the death penalty for 4 years until Gregg versus Georgia, which being stated that because Georgia had new rules and new codes that was more control that allowed the death penalty to happen. And sadly, I disagree with this, but Kennedy versus I think Louisiana was a pedophile had done something to the 8-year-old and then was now not allowed to kill him. Death penalty only results in a death of death. So the death penalty is only allowed if you kill someone.
So cruel and unusual punishment.
Yes, have you learned a lot today?
I have learned a lot. Thank you.